master's office that has to proceed to prevent massive financial loss to our members and by extension the economy. Obviously, our first suggestion is, of course, the confirmation of liquidation and distribution accounts. For those in the profession, though, that is where the IP fee. IP can only take its fee once the L&D account is confirmed. And we suggested to the acting chief master that this be done by email, with our members providing the outstanding requirements, as well as an additional affidavit confirming the date of the inspection period and also confirming that no objections were received. All affidavits, of course, to be signed and commissioned via a teleconferencing, such as we are doing this afternoon with Teams or Skype or Zoom. You know, the problem is that so many affidavits are required that with the lockdown, it is a practical nightmare for members to get the necessary affidavit signed. Our second suggestion has regard to liquidation and distribution accounts. We also made the suggestion that these accounts be lost via email for examination, and then query sheets from the masters then issued and sent back to our members via email. Our third suggestion, and one of the more important and one of the crises that our parties are having at the moment, is that first meetings are obviously not being able to be held because they were all cancelled via the regulations in terms of the DMA.
Sorry, Renee. Sorry, can I just ask you to talk just a little bit more in the mic? Just a little bit more.
Of course. Can you hear me now?
Yes, that's better.
Okay, thank you.
Yeah, much better.
Just to take a step back, I said one of the huge problems is, of course, the first meeting. And no final appointment can be made before a first meeting is held and closed. And the master has the duty in terms of the Insolvency Act to convene first meetings. But it would appear that the government gazette, the government printing works are closed. And that is a huge frustration for us at the moment. So we made the suggestion that that the government printing works offices be open so that first meetings can be convened. We suggested that all meetings be convened to a date in the future. For example, the 15th of June 2020, but with a further protocol in place that should the lockdown be extended, a meeting will be automatically extended for 14 days until normal duty is resumed. We also made the suggestion that the master's office be open and staff work in shifts to accommodate our proposals. I've heard a rumour, I have not been able to confirm, but I have heard that the Director General has requested the Master's Office to open during the final week of the lockdown. They will not be open to the public, but then they can resume their functions and, just to deal with the workload that is obviously being piling up during the lockdown. Kylie?
Yes, thank you, Renee.
Thank you. It's a great pleasure.
Thanks for being on the line. Thank you, Renee.
Thank you. Keep well.
Bye-bye.
Bye. Bye.
Thank you, Renee. Still no connection with our economists, and I think what we should do is we should start dealing with the questions that came through on the Q&A event, and then maybe see if we can get hold of them at the end. The alternative would be that we slot him in for next week's webinar that will be hosted on next week, Thursday. So the first question that came up, and unfortunately we won't have time to deal with each and every question, and some of the questions just also require a more detailed discussion perhaps, which can be addressed in follow-up articles that we will include in our newsletters. But the first question from Stefan Stein is whether there's been a reportable case whereby Section 129, subsection 7 of the Companies act as was successful outcome on Section 1297 to hold the director liable for the debts of the company. So it's definitely not that I'm aware of, and most certainly not that I've seen. To be completely honest, is I've only seen one notice being sent out in terms of Section 1297. The reason for that is that it's commonly referred to as a death notice, because once that notice is sent out, it's an admission that the company is financially distressed, i.e. unable to pay its debts, and it's normally or could be responded to with a liquidation application. So I've never seen a Section 1297 notice being sent or a successful application being prosecuted on that. There was a question on how does business rescue work with trading divisions. So only a company or a closed corporation can be placed in business rescue. So therefore, if a business consists of various trading divisions, if a decision is taken to place that company in business rescue, the entire company will be placed in rescue. And of course, the practitioner would then be able to consider the different trading divisions. Sometimes what happens is that your more profitable trading divisions are sold in order to get a cash flow injection, in order to restructure your company. Or what they do is they put the company in rescue just to sell off the businesses that are not as profitable. So it's a holistic approach in the sense that you can't do division specific. Then I'm going to ask Eileen to answer and to deal with a question that came on what basis and under which circumstances can a practitioner terminate pre-existing contracts in terms of Section 1362 of the Companies Act.
Okay, thank you, Toby. So in terms of 136.2, a practitioner can suspend contractual obligations on the part of a distressed company, and the practitioner can also apply to court to entirely cancel an agreement on terms that are just and reasonable in the circumstances. And this section should actually be seen together with the purpose of the moratorium, which is to give a company some breathing space during the business rescue proceedings. And that is essentially the purpose that this section tries to serve. Because once business rescue proceedings commence, all contracts to which the distressed company is party remain in place. However, in terms of Section 136.2, a BRP is empowered for the duration of the business rescue proceedings, to extricate a company from very onerous contractual obligations that are preventing the company or may later prevent the company from being rescued. So I'll give you some examples of what we experience in practice. For example, lease agreements with very high rentals, or loan agreements with excessive interest payments, supply agreements with unfair pricing arrangements, service or maintenance agreements, and the like are all possible for suspension during the course of the business rescue proceedings. Thanks, Toby.
Thank you, Kylie. There was a question on the effect of the lockdown rules and how would parties then call meetings of creditors, and how would the affected parties come up. At the bottom of the feed, and I'm trying to deal with two questions at the same time, there's also a question then about how do you deal with your employees who sometimes don't have access to smartphones or internet, and how do you communicate with them? So, not that I'm aware of, but in general there's no fixed rules set out as to how meetings should be convened. My initial suggestion would be that if you need to have a meeting during the lockdown period, i.e. let's all hope that the lockdown is not extended again, and if you therefore need to have a meeting of creditors during the course of next week to discuss certain urgent business, the natural suggestion would be to have your meeting via a webinar, electronic means, so via a Zoom call. I've personally attended meetings of creditors before where I was on a teleconference. It's not ideal because sometimes the quality is not as good, but it's possible and there's nothing wrong with doing so. So yes, during the lockdown, you can most certainly still plan for meetings and still convene meetings, similar to what we're having now. There was then a question on the impact of the national lockdown on the implementation of an already approved business rescue plan and the monthly payment obligations. So the way I understand the question is that if in terms of a business rescue plan, the practitioners have suggested to the creditors that certain or the debt will be repaid in monthly installments. And the question then comes up, well, if because of the lockdown and if the company is not an essential service provider and the company is not trading, therefore the company is not deriving any income and as such cannot pay its creditors, what impact would it have? It would be the same impact as in any business rescue plan, regardless of the lockdown or not, in the sense that the plan is binding on the creditors. There's a contract that was created, and the company, through the practitioner, is obliged to effect and to implement that plan. And if it doesn't do so, then the creditors would be entitled and would have a remedy available to them to liquidate the business, or to apply to court to liquidate the business rather. I think people must just be more reasonable, and I think there must be a reasonable approach to that. And of course, if the company cannot pay the monthly obligations because it wasn't trading, because it was forced to close down, then creditors should carefully consider their position, because the company's already gone through a rescue process whereby creditors voted and approved the business rescue plan, which means that they support and they believe in the rescue of the business, and give it some time, maybe go on a round 2 of the rescue process. But in short, the answer to the question is that once the business rescue plan has been adopted, it's binding between the company and the creditors, and it becomes a contract. And you would then have to consider the rules of contract and how to apply any breach of a party's obligations on that contract. There was a question on the appointment of a business rescue practitioner in the case of the board applying for business rescue and what the process is around the appointment. So as Stefan Venter dealt with this in his presentation, I'll ask Stefan to answer this question.
Thanks, Kirby, and thanks for the question. In short, the board of the company must appoint the business rescue practitioner when the board files for business rescue. And this must be done within 5 business days after the adoption of the resolution to place the company under business rescue. It's important to keep in mind that the business rescue practitioner must be someone who satisfies the requirements of Section 138 of the Companies Act. And then after appointing the business rescue practitioner, the company must file a notice of appointment of the business rescue practitioner with the CIPC. And this must be done within 2 business days after making the appointment. And this will typically be done in terms of CIPC form COR 123.2, accompanied by the consent letter of the business rescue practitioner. Lastly, the company must also then be aware that it must publish a copy of the notice of appointment to each affected person within 5 business days after the notice was filed with the CIPC. So yeah, thanks, Kirby.
Thanks, Stefan. There was a question about what happens to the remainder of the debt that the company owes upon liquidation. The way that I understand that question is that once you've submitted a claim and you've only received a 10-cent dividend or 10 cents in the rand of your claim, the question is then what happens to the remaining 90% of that debt? So the first point of call would be to consider whether you have a surety in place for that debt, or whether someone else took surety as security for the debt by the company that's been placed in liquidation. And if so, you would be entitled to enforce the rights on that suretyship agreement. Alternatively, if the company is the sole principal debtor and responsible for payment of the debt, unfortunately, after you receive your dividend, that portion will be discharged because the company will be dissolved on the liquidation upon the finalization of the liquidation proceedings, and therefore the liability will no longer be in place. There were quite a lot of questions coming up through the employment issues in a business rescue process and also through a liquidation scenario, and I will answer in them to the best of my ability, not being an employment law specialist. So I'll give short answers, and I think what would be appropriate is to maybe identify these questions and to group them together in an article that we can include in the next edition of our weekly newsletter. But in short, a question was posed as to whether a company can run a Section 189 process concurrently with the proceedings of business rescue or during a liquidation process. So yes, of course, in order to, the Companies Act is very clear, and as well as the Insolvency Act, that when you deal with your employees in a business rescue and a liquidation scenario, that you must comply with the regulations set out in our Labour Relations Act. So yes, you can run a process concurrently. Then there were quite a lot of interest, I see, on the notice that was issued by SIPC on the DA's non and the effect of that notice, and whether companies can still file for business rescue and how to go about the filing of the business rescue, which in my mind is a positive sign, because it shows you that our clients out there are considering their rights and their obligations. It seems that the board of directors of companies that may be financially distressed are considering their fiduciary duty, specifically the duty set out in Section 1297 of the Companies Act. I think what best to deal with the request is that Stefan and I are already working on an article that will be published in our newsletter, the edition for this coming Tuesday, dealing with specifically the CIPC notice and the DA's non-effect, and whether you can file for rescue and appoint a practitioner during lockdown or not. So my suggestion is that we rather deal with and group all those questions together in that article in the Tuesday's edition. There was a question about if a dispute should arise on the valuation of assets on either liquidation or business rescue. So in a liquidation scenario, the majority of assets are sold on a forced sale basis. So your value is normally determined on a willing buyer, willing seller, and what willing buyers are prepared to pay for the asset. And there can't really be a dispute. Of course, if the asset is overvalued or undervalued, there would be certain rights for the creditors of that company would have rights to approach the master and to approach the liquidator and to file objections and to say that the asset was not properly valued or was sold for undervalue by the liquidator, because it would of course have the effect on the return that a creditor would receive in a liquidation or in a business rescue scenario. So creditors are not completely without remedies. And if it would mean that the asset is undervalued, it can certainly be addressed. Okay. There was a question as to whether creditors can claim assets that are owned by businesses in foreign jurisdictions. And the example was put that if there's a vehicle in Brazil which was purchased by the now liquidated company, and the question is then whether, how do you go about getting your hands on those, let's call it, foreign assets? It is most certainly possible. The question is a little bit more complex because there are different rules that will apply and different association and treaties between different jurisdictions. But in a nutshell, and to get to the point of the question, is that it is possible to trace those assets. As a start, what you would have to do is you would have to recognize the liquidation proceedings in that foreign jurisdiction in order to be able to attach that asset in the foreign jurisdiction and to have it sold so that the proceeds can come to the liquidation and distribution account. There was a question on how employees' claim is calculated and dealt with in a liquidation, and I'm going to ask Hossein Kaseng to deal with that question.
Yeah, thanks, Toby. I mean, just in very short, the employees have got a claim, for all their arrear salaries, leave pay, severance, or retrenchment pay. And what happens then is that a portion of their claim is preferent, but that's limited to 28,000 Rand. I speak under correction. I hope that's still the amount. And then the balance of their claim then will be a concurrent claim. Thanks.
Thanks, Hossein. There's no question as to the difference between a sale by way of private treaty and public auction, and who decides on this route. So ordinarily what would happen is if a liquidator wants to dispose and sell off the assets of the company in a liquidation, he would have to be empowered to do so. liquidators' powers are typically extended and given at the second meeting of creditors only, where various resolutions are adopted and placed on the table for creditors to consider and approve. But it is sometimes necessary, given the urgency of a specific matter, for liquidators to extend those powers at an earlier stage. Ordinarily, an application will be brought to the master or to the High Court by the liquidator asking the master to extend his limited powers. In that extension application, the liquidator will typically ask for both. So he would ask for an extension of his powers to sell property, movable or immovable, either by way of private treaty or by auction. The reason why he would ask for both is that he would want to, and of course it would be one of the goals of a liquidator, to ensure that he or she sell and dispose of the assets for as much as he possibly can, in order to get as much proceeds in as he possibly can to settle the creditors. So I would say the answer is that the liquidator will decide on the route as to how to dispose of the assets, because ultimately that's one of his duties, to dispose of the assets and to liquidate the assets in order to pay the creditors. But typically it would be included in his extension of powers application. If there's no application, it would be through resolutions that are adopted at the second meeting of creditors. Okay, then the next question. I'm just trying to quickly see what the next one is. So there's a question about how does business rescue affect a director's rights and duties under the Companies Act. So one must remember that as soon as the board resolves for a company to be placed in business rescue, the directors remain directors of the company. It's just that they no longer have any authority to act, in the sense that all decision making will be taken place or will be done by the business rescue practitioners. And the directors are there to assist the practitioner in rescuing or trading or continuing with the business operations. But the filing for business rescue does not affect a director's rights or duties under the Companies Act. So, an interesting question that often come up in a rescue scenario is what happens when a company is in distress and retrench the staff as part of the rescue proceedings. Then they're not able to pay the severance packages. So once a company is retrenched, once employees are retrenched in the business rescue process, the employee will become entitled to payment of the retrenchment package. The question then further goes as to whether that specific employee or that claim, is it in a preferential nature, in the sense of an employment-related expense or claim, or does that employee become a normal concurrent creditor and the entitlement to be paid is just from the severance package or the severance agreement? It's the same. My answer to that is that it's the same as with any other creditor that the company cannot pay in terms of an adopted business rescue plan. So if the plan, remember, through the plan it would provide for the retrenchment of employees, or it could potentially provide for the retrenchment of employees, and the plan would have to provide for how payment will be made available for those employees. And if it's the same, and it's nothing different to creditors being paid their claims in the rescue and how the company will go about paying it. So if there's no money, it's the same as if there's no money to pay creditors, which is the same as the first questions that one of the first questions that we answered as to what happens if the company can't make payment of those monthly obligations in terms of an adopted business rescue plan. And the answer is again that it goes back to the law of contract, because there's a binding contract in place between your creditors and the company when a plan is adopted. There's an interesting question on the fees of a business rescue practitioner. So the business rescue practitioner's fees are set out in the Companies Act, and there's a tariff that applies, and it's a different fee for different seniority and also the size of the company. The size of the company is determined at the filing of the rescue, when the board is required to indicate their public interest scoring, because it affects the size. It's either going to be a small or medium or a large company. Practitioners however, are not bound by that prescribed fee structure. Often what you see is right at the beginning, when the board meets up with a business rescue practitioner, remuneration agreements are agreed and set out right at the beginning of the rescue process. Sometimes it's also possible for practitioners to include a success fee in a successful business rescue plan, and it's been the topic of a recent decision in our Supreme Court of Appeal, which allows for business rescue practitioners to be entitled to receive a success fee through a business rescue plan. So yes, practitioners' fees are set out in the Companies Act. There's a straightforward tariff that is implied and can be applied, but there are deviations to that rule. Then there's a question about whether business rescue practitioners are entitled to commission for the sale of assets. It depends on the relationship, it depends on the agreement that the practitioner has reached with either the company or the company's shareholders. But it's not as with a liquidation where there's a tariff set out where liquidators are entitled to a certain percentage or a commission on the sale of, for instance, immovable property, movable property, or the collection of debt. Sure, then there's a question of the basic requirements to qualify as a business rescue practitioner. So the Act does assist in setting out those requirements for us, and it's dealt with in Section 138 of the Companies Act under the heading the qualifications of a practitioner. Ordinarily, it is that the practitioner must be a member in good standing of a legal, accounting, or business management profession. He must be licensed by the by SIPC, by the Commission. He's not subject to an order of prohibition. He's not disqualified from acting as a director, and he does not have any other relationship with the company, such as would lead a reasonable and informed third party to conclude that his integrity may have been compromised. So there must be some form of independence. So I just repeat that your requirements and the qualifications of the practitioner is set out clearly in Section 138 of the Companies Act. There's a question on whether, if the master has approved the L&D account, can the liquidator make, and the L&D is short for liquidation and distribution account, and whether the liquidator can make a short payment to creditors, or are they obliged to make payments in line with the account? So there's a principle of advanced dividends that are being paid. One must also remember that sometimes there are more than one liquidation and distribution account. And all these accounts must be approved separately. So you'll start off with a first liquidation distribution account, and in that account, the liquidator will propose to the master what proceeds he has received from the liquidating of the assets and how he intends to distribute the proceeds to the creditors. Payment must be made in terms of that distribution account and can't be short paid, but it's possible that a creditor would only receive his dividend on the second or the third approved liquidation account. So there's another question on the CIPC extension notice that we will deal with in our article that will come out on Tuesday. Then there's a practical question, I would imagine, on the effect of lockdown on the process of serving a court order of a provisional liquidation on a company or on their employees. So that's actually something that we are dealing with at the moment, where we have a provisional liquidation order in place, with a return day that's been set down in the lockdown period. And in this specific jurisdiction where we are, the court has made a decision not to hear any matters unless it's urgent, and there are also again a list of requirements set out for matters to be classified as urgent during lockdown. Unfortunately, what we have is that the return day must again be extended, because otherwise it will lapse. And a second application, a follow-up application, will then have to be brought to reinstate that provisional order. But unfortunately, we're sitting in a scenario where we cannot serve. We cannot serve our provisional order because the sheriff is not willing or can't assist us with the service. So it does have a detrimental effect. I would imagine that we may see a practice directive maybe coming out to this regard to assist practitioners and attorneys in dealing with return dates that have been missed because of the lockdown period. Currently, I can't offer any other solution to that problem, but to at least provide assurance to the client that even if, worst case scenario, that provisional order would lapse because it was not made final on the return date, there's always the option of bringing an application to reinstate. Then there's a question about lease agreements in business rescue and whether that can be suspended. So the question is whether a contract of lease can be suspended by a BRP or payment of rental be suspended or reduced unilaterally by the BRP whilst the BRP continues to occupy the premises. And luckily over time we've seen some clarity on this question, where right in the beginning of business rescue practitioners, sometimes one of the main reasons for company adopting a resolution to place itself in a business rescue was to avoid making payment of its rental obligation and then to hide behind the legal moratorium and to say that they can't be evicted from the premises. So the case law has developed on that, and cancellation of agreements have been seen not to be enforcement agreements or enforcement actions which are prohibited by the moratorium, which is set out in section 133 of the Companies Act. The general rule of thumb and the advice that we give to clients on that is if there's a breach of an agreement, you follow the breach clauses of that agreement, irrespective of whether it's a lease agreement or any other contractual agreement that's in place. You give effect, you give notice, and you follow the rules of that contract, etc. Thereafter, you provide for the cancellation of that contract, and you then enforce your rights thereafter. If it is an eviction, you must obviously first ask the practitioner for his consent to litigate against a company that's under business rescue. And if that consent is not provided, then you can apply to court as a first pre in your application in the eviction application to then ask the court to uplift the moratorium for the specific circumstances and for allowing the landlord to institute proceedings against the company in business rescue for its eviction.